In Florida, there are 6 basic or core agreements that most businesses in most industries should have. First and foremost is the non-compete agreement. At its core, a non-compete agreement is where the employer is trying to protect from the ex-employee competing with the business in a reasonable geographic area and for a reasonable amount of time. The second is a non-solicitation agreement, and that is simply where you try to prevent the disgruntled ex-employee from stealing the company's clients, vendors, suppliers, things like that. The third is a non-disparagement agreement, and it is basically what it says. It's to keep the ex-employee from bad-mouthing you or the company and nowadays putting comments on social media. Fourth is a confidentiality agreement, and that is again what the title says. It's to keep what happens at your business. Confidentiality agreements also include protection of trade secrets. The fifth agreement is the employee independent contractor agreement, and what that is it tries to explain what the person actually does for your company and why you're classifying them in a certain way as an employee or independent contractor. The key is to remember that just having a 1099 for someone and calling them an independent contractor does not legally make them an independent contractor. And the sixth agreement is a separation agreement. It's last, but it's not least. It can be one of the most important. What it's used for is to spell out the terms and conditions of the employee or independent contractor's departure from your company. It can reaffirm all the prior agreements. It can explain any payments that are owed to the person, and it may include a transition agreement whereby the ex-employee is to help out in certain matters for a certain period of time.